Good afternoon. Welcome to Can They Do That? My name is Kiren Choudhry, and I'm a senior associate here at the Scott Law Team. Now, a big part of my practice here at the firm is litigating breach of contract cases, specifically dealing with restrictive covenants. So we get a lot of questions, about the enforceability of restrictive covenants. Hence, we are here today to answer the big question. Can they keep me from working for a competitor? And the short answer is, well, it depends. And I guess that's the answer to many legal questions. So let's talk about the different types of restrictive covenants. And for the purposes of this presentation, let's work with the hypo and assume you're working for ABC Corp. Your employer may have you sign a non-compete, which basically restricts you from working for a business competitor for a certain period of time after your employment at ABC Corp ends. There may be a non-solicitation clause in the agreement, which may prevent you from soliciting other employees of ABC Corp or soliciting ABC Corp's customers and clients. There may be a non-disparagement clause, which restricts you from speaking ill or bad-mouthing ABC Corp after you leave because that hurts their reputation. And the big one is confidentiality. ABC Corp can restrict you from divulging any business confidential information. They have the right to do that, and they can restrict you in perpetuity. Now, I get this question a lot. Why does my employer want me to sign restrictive covenants? Well, your employer, or ABC Corp here, invests significant amount of time, effort, and money in building a business, which includes marketing, training their employees, developing certain products, forming and cultivating relationships with their customers. And these are what we call legitimate business interests. And they have a right to protect their investment and business interests, of course. They don't want you to start working with them, get trained in the industry, learn the ins and outs of the business, develop a relationship with their clients, and then leave and take all of that valuable business information to a competitor or start your own business perhaps, because that would not be fair. So they ask you to sign these restrictive covenants to protect their business interests. Now, this is important to remember. The restrictive covenant must be in writing and it must be signed by you. Restrictive covenants don't necessarily have to be in employment agreements. They can also be in offer letters. So please be on the lookout for that. Now, what does ABC Corp do if you sign the restrictive covenants and then start violating them after your employment ends? Well, they can file an action against you and seek a temporary and permanent injunction, which is basically ABC Corp asking the judge to stop you from competing with them, stop you from soliciting their employees and or customers, stop using their confidential or proprietary business information, or they can seek damages for the harm that you have done to their business by violating the restrictive covenants you signed. Now, how do you defend against an action against you by ABC Corp? Well, in order for a restrictive covenant to be enforceable, it has to be reasonable in its temporal and geographic scope. So for instance, in Florida, courts will most likely find a restrictive covenant for 6 months or less to be reasonable. Anything more than 2 years is presumptively unreasonable. And as far as the geographic scope is concerned, it all depends on the facts of each case. You may be restricted from working in any given county or even the entire state of Florida. It all depends on your position, the employer, the industry that you're in. So it's tough to discuss that at length today, frankly. A restrictive covenant also has to be supported by a legitimate business interest, as we discussed a few minutes ago. So let's say, did you become privy to ABC Corp's valuable confidential business information, information that is not available to the public? Maybe, did ABC Corp provide specialized training to you during your employment with them? During your employment, did you become privy to information regarding ABC Corp's customers, who ABC Corp has a substantial relationship with? If not, then a court may find that since ABC Corp does not have a legitimate business interest they are trying to protect, you should be free to work for a competitor. Now, a big defense, and we see a lot of these types of cases, is that ABC Corp, your employer, breached the contract first. So let's say if ABC Corp failed to pay you according to your agreement with it, you can tell the court, Your Honor, or ABC Corp hasn't paid me according to our agreement, so I should be relieved from any obligations in that agreement. Or maybe ABC Corp sat on their rights and did not file an action timely, or move for an injunction in a timely fashion. That would be a defense. There's a defense of unclean hands. Let's say ABC Corp has done something unlawful, which renders the restrictive covenants unenforceable. Or in other words, ABC Corp did something egregious and you should be relieved from your obligations under that agreement. Then there's lack of actual harm. You can say, yes, Your Honor, I'm working for a competitor, but it is not causing any harm to ABC Corp. Maybe you were working in a different role than while you were at ABC Corp. Maybe you are not soliciting their employees or customers. Maybe your job description at your new employer is completely different. That would be a defense. And then there's selective enforcement. Let's say John Doe left ABC Corp, started working competitively, violating his restrictive covenants, and ABC Corp did nothing. They did not try to stop John Doe and others from working competitively. Well, then you shouldn't be allowed, they should not be allowed to single you out and bring an action against you. That's the defense of selective enforcement. Now, of course, there are many other defenses, but because I've been told that our time for this presentation today is limited, I have only included a few big defenses. And which defenses we raise when defending an action against you also depends on, obviously, in each individual's case and the set of unique facts. Now, finally, in Florida, we also have the blue pencil rule, and a lot of other states also follow this. If the court finds that the restrictive covenant is overbroad in its scope, or it's not reasonably necessary to protect some legitimate business interest of the employer, the court has the right to modify that restraint and only grant relief that is reasonably necessary to protect ABC Corp's interests. And before I forget, I get this question a lot also. Should I tell my new employer about my non-compete? Absolutely. Most employment contracts will have a clause where you agree to inform any subsequent employer about the restrictive covenants contained in the agreement. So your new employer may also ask you to sign an acknowledgement that you have not signed any restrictive covenants with your previous employer. So please tell your prospective employer about the non-compete you signed with ABC Corp. If you don't, your new employer might also be sued by ABC Corp for tortious interference, but that's a topic for another day. I hope this session helped answer some of the questions you all have been sending to our office. If you have any other questions related to restrictive covenants or any other labor and employment related issue, feel free to email us. The email address is intake@scottlawteam.com. Thank you all for joining me today for another part of the series we call Can They Do That? Have a great day.